Okay. Okay, it looks like we have Mr. Goff present here by Zoom, so we'll go on the record in that case. This is Brandon Bird versus Goff, case number 0913272. Again, Mr. Goff is joined by Zoom. We have Ms. Krause present on behalf of friend of the court. This is set for a hearing regarding payment of child support. And Ms. Krause, can you tell me where things stand with this file today?
Yes, as of this morning, I just looked about a half an hour ago. It looks like he did make an additional payment of $150. So he has made a payment of $100 in May of this year. And then that payment that was this morning that I actually almost overlooked. Outside of that, his balance is still $16,010.47. And he does have an obligation of $324.
Okay. And that, where do we stand in terms of going forward for the month of June then? Is that 150, is that applied to a prior May payment or?
That payment was received this morning, so it can take 3 to 5 business days. It should be applied to this month's obligation as long as there's no other court cases or anything like that that I'm aware of, because it's still pending right now.
Okay, got it. And so then that would still leave the balance of the 324.
That would be minus that for this month if it's set to this case.
Right, okay. All right. And then how do you want to proceed going forward? What's your recommendation?
I still believe that we would still seek contempt. We would request that he be committed, but based on that payment. And again, this morning, we've not had any contact with him in regards to not being able to make payments or discuss steps for taking to gain employment. So outside of that payment a half an hour ago, I would have requested that he be committed to 50 days in jail. So I'm really not, I guess I would need some direction from you as well.
All right, okay, thank you. Mr. Goff, what's your situation in terms of employment at this time?
I am unemployed. So I was gonna add just anything that I was able to, that I would probably be able to put another 50 on this week. But as far as terms of employment, I am just unemployed at the moment.
Okay. All right, so what I'm gonna order is, Mr. Goff, I'm gonna order that you report to the friend of the court office within the next 7 days.
7 days.
Because obviously if you're unemployed, you're not gonna be able to make a $324 a month payment, which means you're just gonna continue to have bench warrants issued, you're gonna continue to build up arrears. So something needs to be done. And it sounds like you're not going to the front of the court and trying to find solutions to this on your own. So I'm going to order that to happen within the next 7 days. And then I'm going to order you, I suspect, Ms. Krause, you're going to have Mr. Goff, provide whatever job search efforts he's undertaking and provide you with that kind of information once he meets with whoever the caseworker is.
Yeah, we can discuss that, and absolutely we can go over some options, and I'll just indicate if it's not done, then we would you potentially set it for another hearing with you, or would you prefer it to go back in front of the referee?
I'm going to set it for another review hearing next month here in this court. So Mr. Goff, again, you need to meet with friend of the court. You need to comply with whatever they're asking you to do in terms of job search requirements or whatever paperwork that you need to submit if there's going to be a modification of the amount. But again, we either need to get that amount adjusted, or you need to start paying that one way or the other. So if you haven't made those kind of efforts, and if you don't follow whatever the direction of the friend of the court is when you meet with them in the next 7 days, then at that point, you're not gonna be leaving me with much choice other than to impose a jail sentence as a sanction to hopefully spur things along. So we'll set this for another hearing in July. Ms. Kraus is going to report to me at that point what efforts that you've undertaken and what degree of compliance we have from you, Mr. Goff. And that's going to depend on whether or not we continue forward, or whether you're going to have to serve jail time. You understand that?
Understood.
Okay. All right. Ms. Kraus, anything else we need to address on this file today?
No, thank you.
Okay. Thank you. Mr. Goff, you're free to disconnect at this time.
All right. Have a good day.
Thank you. Okay, we've got somebody who's joined us on the phone with the last 4 digits of 1346. Can you tell me your name, please?
My name is Ethan Robertson.
Mr. Robertson. Okay. Okay, Mr. Robertson, I'm just going to put you on hold for just a minute. I got a couple other files that I have to address real quick, and then I'll bring you back in, okay?
Okay, thank you.
Thank you. All right, so we did have a number of other files set for hearing with friend of the court this morning. They were all set for 9 a.m. I don't have anybody else in the Zoom waiting room. So let's see, the next one is Fritz versus Gall, case number 1013413. The record should reflect that neither party has appeared on that file. On that one, Ms. Kraus, how did you want to proceed?
Well, per the arrangements from the hearing on 5/17, the defendant has complied with the request of the court to pay $300 and report employment by May 20th. Since then, the reported employer has indicated his employment has terminated as of May 14th. The defendant has a support obligation of $111 and a balance of $1,560.95. I'm actually surprised that he's not here. We were going to request, given the information, friend of the court would request the defendant to be ordered to contact the office by the end of this week to discuss employment, and then be ordered to appear before referee Kyle Legal on July 10th at 9 a.m. I still feel that would be appropriate.
Okay, I agree. And if you'll prepare an order on that, and then if he doesn't appear before referee Legal, then I think it would be time to send it back here to this court.
Okay, thank you.
All right, next one is Snyder versus Gibson, case number 1214528. Again, for the record, neither party has appeared on that file today. How did you want to go forward on that?
And just to be clear, it was with Gibson, correct?
Yes.
Thank you. This hearing was adjourned from April 5th, when the defendant was released on a PR bond with conditions that required him to make specific payments to the case and return a physician form. 2 payments have been made on behalf of the defendant, but were made by a third party and distributed to another case that's actively charging. This is an arrears only case with a balance of $1,316.81. After the review of the submitted information, friend of the court would request this matter be set before the referee on August 21st at 9 a.m. to continue monitoring the defendant's situation.
Okay, the court will order that this be set for hearing before the referee, as you indicated, in August.
Thank you.
The next file is Brown versus Koshelniak. That is case number 13-14961. Again, for the record, neither party has appeared on that file. How did you want to proceed on that?
On May 1st, the referee Legal recommended the defendant be found in contempt. Referee legal was satisfied that the defendant has the capacity to pay all or some of the amount due out of available resources and has not made good faith effort to make payments pursuant to the referee's recommendation. The friend of the court would seek that the defendant be found in contempt of the court.
Okay, based on the referee's finding and Mr. Koshelniak's failure to appear this morning, I would request that you prepare a bench warrant. The court will sign that, and then we'll proceed further once Mr. Koshelniak's arrested and brought before the court.
Thank you.
And then last one I have is Coma versus Coma, case number 2218820. Again, for the record, neither party on that file has appeared today. And can you tell me the status of that case?
Yes, on May 1st, referee legal recommended that the defendant be found in contempt. Referee legal was satisfied that the defendant had the capacity and resources to pay more towards his obligation in arrears than he has been. Additionally, the defendant has appeared in front of the referee for show cause hearings multiple times since November of 2023 and has been given multiple opportunities to make payments and comply with the court order. Pursuant to the referee's recommendation, the friend of the court seeks the defendant be found in contempt of the court.
Okay, thank you. As with the previous case, the court will request that the friend of the court prepare a bench warrant for Mr. Coma's arrest, and we'll proceed further on that once he's arrested and brought before the court.
One question, Judge.
Sure.
In regards to this particular defendant, I believe he is not located in this state. Would that still be?
Yeah, I mean, we still need to have the bench warrant issued so that's
Okay.
in lien, and if he does come back, then he could potentially be picked up. So yeah, I still would like to have that in the record.
Okay, thank you.
Any other show cause files?
Not that I'm aware of.
Okay, sounds good. Thank you.
Yeah, I appreciate your time. Thank you.
Okay, Mr. Robertson, are you there?
Yes, Your Honor.
Okay. All right, we'll go on the record and Robertson. This is Robertson. This is case number 2319524. The record should reflect that Mr. Robertson is present today by video, or I'm sorry, by phone through Zoom. I do not see Miss Robertson present. Is she with you, or is she just not appearing today? Do you know?
I do not know what she is doing. She's not currently with me or around me right now, Your Honor.
Okay. I have this set for entry of a judgment of divorce today. I do have a proposed judgment here in the file. Did you want to proceed with finalizing the divorce today?
Yes, please, Your Honor.
Okay. All right. Based on Ms. Robertson's failure to appear, and it does appear that she was given notice of the date and time of today's hearing, which was set for 9, and it's now 9:17. The court is in receipt again of a proposed judgment that she signed. So we're going to proceed, and to the extent she wants to challenge the judgment, she'll have to do that later. Mr. Robertson, if you can raise your right hand and tell me once it's raised, please.
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, Your Honor, I swear.
Thank you. You can lower your hand. Mr. Robertson, I'm going to ask you a series of questions. The questions I'm going to be asking are the questions I'm required to ask to establish the grounds for divorce under Michigan law. You did not file the complaint in this case, but at the time that the complaint was filed, to the best of your knowledge, had Ms. Robertson been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
And to the best of your knowledge, had she been residing in Otsego County for at least 10 days at that time?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true at the time that this complaint for divorce was filed?
Yes, Your Honor.
And is that true still today?
Most definitely so, Your Honor.
Okay. And there was one child born of the marriage, is that correct?
That is correct, Your Honor.
And that child is still under the age of 18 at this time?
Yes, Your Honor.
Okay. And under the judgment of divorce, you and Ms. Robertson would both share joint physical and legal custody of your child. Is that your understanding?
As far as I'm understanding, that is correct, Your Honor.
Okay. And as the father, do you believe that that would be in your child's best interests?
Yes, Your Honor.
Okay. In this case, let's see. There is also going to be provision that you're going to pay spousal support to Ms. Robertson. Is that correct?
Yes, Your Honor.
And that would be in the amount of $200 per month, starting on July 1st of 2024 and going through November 28th of 2026. Is that correct?
That is correct, Your Honor.
And in terms of any other property or debts of the marriage, you and Ms. Robertson have agreed on how to divide all of those things up. Is that correct?
That is correct, Your Honor. Person to person, we have agreed what is fair between the both of us.
Okay. And you don't own any real estate or real property together. Is that also correct?
Correct, Your Honor.
Okay. To your knowledge, is Ms. Robertson currently pregnant?
To my knowledge, no, Your Honor, she is not.
Okay, thank you. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Mr. Robertson. The court will grant the divorce. And I'm signing that judgment of divorce with today's date. Mr. Robertson, if you would like to have a copy of that for your records, you can get a copy of that here at the clerk's office at the courthouse in Gaylord. Do you have any questions at all?
No questions at all, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Okay, thank you. I hope you have a wonderful rest of your day, sir.
Thank you. Okay. Mr. Lasher, can you unmute, please?
Yep.
All right, are you able to hear me okay?
Yep.
All right, and Ms. Lasher, you're gonna need to go into your Zoom app and connect your audio. There we go. And then now I just need you to unmute as well. Ma'am, are you able to hear me okay?
Yes, now I can.
Thank you. We're on the record now in Lasher versus Lasher, case number 2319538. The record should reflect both parties are present by Zoom video. I had this set for entry of a final judgment of divorce today. Ms. Lasher, is that how you wanted to proceed?
Leslie.
Yes.
Ms. Lasher? Yeah, okay. And Mr. Lasher, is that how you wanted to proceed as well?
Yes, sir.
Okay. All right, I'm gonna place both of you under oath, and then I've got some questions that I need to ask each of you. The questions I'm gonna be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes,
Okay, thank you. You can both lower your hands. Ms. Lasher, my questions are gonna start with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
yes,
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
no,
Okay, when did you begin residing in Michigan?
You've been a resident your whole life in Michigan, Lizzie.
my phone's cutting in and out really bad.
You've lived in Michigan your whole life. So yes, you've been a resident the whole time.
All right, Ms. Lasher, if you can turn off your video, if you have a limited signal, if the video is off, sometimes that helps with the audio part of it.
Okay,
All right, are you still able to hear me?
yes,
Okay, have you lived in Michigan for at least 180 days?
yes,
Okay, and have you lived in Otsego County for at least 10 days?
yes,
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that your marriage could be preserved. Was that true when you filed the complaint?
yes,
Does that remain true today?
yes,
All right, and there are 2 minor children that were born of this marriage, is that correct?
well, they were born before the marriage.
Okay, but they were born between you and Mr. Lasher?
Yes,
Okay. And are you currently pregnant at this time?
no,
All right, and under the judgment of divorce, you and Mr. Lasher are gonna share joint legal and physical custody, essentially equal amount of custody between the 2 of you regarding your children, is that correct?
yes,
Okay. All right. And you understand, Ms. Lasher, that you are not gonna receive any alimony or spousal support as part of the judgment.
yes,
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
yes,
Okay. And in terms of that custody arrangement between you and Mr. Lasher regarding your children, do you believe that that would be in your children's best interests?
yes,
Okay. Mr. Lasher, have you heard all the questions that I asked Ms. Lasher?
Yes, I have.
And have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
And you understand that you and Ms. Lasher will share joint legal and physical custody of your children?
Yes.
And as a father, do you agree that that would be in their best interest?
Definitely. Or yes.
Okay. All right, and you understand you also would not be receiving any alimony or spousal support?
Yeah.
And you understand that you also would be waiving that forever and you would not be able to come back later and ask the court for that?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of the parties. I do have a proposed judgment that was submitted, and it does contain all the provisions required by statute. So the court will sign that, and the court will grant the divorce. All right, so if either of you want to have a copy of this judgment of divorce for your records, you can get that here at the clerk's office at the courthouse in Gaylord. Ms. Lasher, do you have any questions at all?
no, I do not.
Mr. Lasher, do you have any questions?
Nope.
Okay, thank you. That's all for today, and both parties are free to disconnect at this time.
Thank you.
Yep.
You have a good day.
Our next hearing's at 9:30. I don't see the parties yet in the Zoom waiting room, so we'll take a short recess. All right, ma'am, on the Samsung device, if you can unmute, please.
I'm
Hi,
early.
can you tell me your name?
Carly Fox.
Oh, Miss Fox, okay. Yep, I'm just gonna put you back in the waiting room for just a few minutes, okay?
Okay,
Thank you.
you're welcome.
Okay, we'll go on the record in our 9:30 hearing. This is Morrison versus Morrison, case number 2319363. And Ms. Kraus, if you're there, you hop on for a second. Thank you. This is a case, first of all, this was set for 9:30. It's now 9:35. Neither party has appeared in the Zoom waiting room. The court attempted to finalize the divorce in this case back in March, at which time I believe the plaintiff testified that she was currently pregnant. Do you have any updates, Ms. Kraus, on where that part of this case is?
Yes, based on that hearing in March, the friend of the court did mail information the following day to the plaintiff. She did contact the office on March 12th requesting the information. We relayed that it was mailed and she requested that we remail it, and that's the only contact that we've had.
Okay. All right. I'm gonna set this for one more status conference in 30 days. If neither party appears for that hearing and there hasn't been any further progress in terms of their contact with friend of the court to get this paternity issue resolved, then the court will consider just dismissing the case at that time. Thank you for the information. I appreciate that.
Yeah, you're welcome. Thank you.
All right, and then our next file is Goddard versus Goddard, case number 2319521. That one was also set for hearing at 9:30, and neither party has appeared for that. This notice was sent out in April for today's hearing. At that time, the court notified the parties that they needed to submit a proposed judgment. They haven't done that, and again, neither side has appeared today. So as with the last case, the court will set this for one more hearing in about 30 days. If neither party appears, at that time the court will consider file as well. Our next hearing is set for 9:45, so we'll take a recess until that time. Okay, Mr. Dundon, are you able to hear me okay?
Yes, I can, Your Honor. Thank you.
Okay. All right, and we have Ms. Fox connected. We also have Mr. Fox connected. Mr. Fox, are you there? Can you hear me?
Yeah, I cannot make no uh um lawful decisions right now. I just had heart surgery.
Okay, all right. Well, I'm gonna hear from Ms. Fox's lawyer, and then we're gonna see where we go today. Mr. Dundon, you filed a motion here today for entry of default judgment of divorce. Is that correct?
That's correct, Your Honor. As we explained in the motion, custody has already been addressed. Mr. Fox filed a complaint or filed a motion to change it and then withdrew it and then has not filed since to address custody. I've tried to talk to him repeatedly. The issue here, and just so the court's aware, I believe we explained it in here, there's very few assets. I mean, almost next to none. So we were hoping to simply complete the case, enter a judgment, and obviously Mr. Fox, as he is now, is free to file another motion in the FOC if he wants to change custody. This is the first time I've heard from him, and I'm not giving him a hard time if he's been going through these had health issues. I just have not been able to get with him at all, Your Honor. And I was just hoping to enter this judgment. I emailed it to him. And again, in my humble opinion, it doesn't stop him from, again, bringing his motion at any point in front of the court, Judge.
So, Mr. Dundon, did we take proofs in this already back in, I think we had a hearing last month, didn't we?
Your Honor, I apologize. I don't have my note. I don't think we did, but I don't want to be wrong. I'm sorry, Judge.
No,
Molly.
that's all right. Susie, can you look and see if when our last hearing was and if there are any notes on that?
We had a hearing on April 2nd, or excuse me. Oops.
Molly.
We had a hearing on April 1st, and the plaintiff was not present. The plaintiff's attorney was not present. Defendant was entitled to default. We took proofs placed on the record, and the divorce was granted. The court set a control date of 60 days, and Attorney Dundon to submit the judgment of divorce.
Okay.
And that was April 1st, sir.
I apologize, Your Honor. Thank you. I guess that's been done, sir.
Okay. All right, Mr. Fox, was there anything that you wanted to say today?
He cannot speak because
Okay,
his
who am I
doc,
who am I talking to right?
I'm his mother. I make all the decisions for him. I go through the state of Michigan.
Okay. All right. Well, how we're going to proceed today, the court's already granted the divorce. Mr. Fox has failed to appear for the last two hearings, so the court found him in fault. And the court's already taken proofs, so at this point, the court finds it is appropriate to enter the judgment that was submitted by Mr. Dundon. So I will sign that with today's date.
But when we took her to court, now she wouldn't sign ours through Dave Leonardson. She wouldn't sign the divorce. Now, why is that right?
You know what, ma'am? If you're not a lawyer, I don't have anything in writing that says that you have power of attorney or that you have the ability to speak for Mr. Fox today.
It's through the state of Michigan. You can look it up.
It's not my job to look things up. If you want to speak on his behalf, you have to submit documentation to the court that shows that you have the ability to do that. And I don't have
will
anything.
get it. I'll get
Well,
it
it's-
for you.
He doesn't need to be.
You can, that's fine, you can submit whatever you want later on, but it's not gonna stop the court from proceeding today because, again, Mr. Fox has been found in default, he hasn't appeared.
We
Court's
haven't
got
received
first
nothing.
hearings since March,
Now,
and he hasn't
why is that
appeared
right when we have not received nothing? That attorney only called him.
It's on my phone.
It's on his phone 2 times. There's nothing else. This notice we just got this morning, I picked it out of the mailbox. It wasn't in there Friday.
Okay. Understood. Either way, he hasn't appeared for the last 2 hearings and the court already found him in default for his failure to appear.
Then
So
we should have got a notice.
you did, the court sent out notices for those hearings.
There was no notice. No notice. I pick his mail up every day.
That's fine. I understand that's what you're saying. What I'm telling you is, as far as the court is concerned, you were sent notice, so.
There was no notice, sir.
I'm not gonna argue with you about it. It's not a debate. You can challenge the judgment later if you want to do that, but at this point, the court's moving forward. Mr. Dundon, the court does need you to submit the uniform child support order from front of the court for this to be final, but I will sign the default judgment today.
Will do, Your Honor. Thank you.
And I'm gonna ask you to do that within the next 14 days.
Yes, sir, will do.
Okay, all right. That's all for today's hearing. All parties are free.
Thank you, Your Honor.
Have a good fun. It's all my rights to say that. Freedom of speech.
Okay, if I could have both of you unmute, please. Thank you. All right, we've got both parties connected. This is Heins versus Heins, case number 2419641. And ma'am, are you Ashley Heins?
Yes, sir, I am.
And sir, you're Anthony Heins, is that correct?
Yes, sir.
Okay. All right, we're on the record here today for a pretrial scheduling hearing. I know that it looks like the two of you have had some hearings in front of the court and maybe have some agreements on custody and so forth. The purpose of this hearing today is for me to determine whether or not there are any issues regarding the division of any marital assets or debts, or whether you guys have been able to reach agreements as to those things. And that includes things like spousal support or alimony. Ms. Heins, from your standpoint, where do things stand with regard to dividing up the assets and debts?
We're in agreement for all of that.
Okay. Mr. Heins, what's your position?
Yeah, we've done good. We've pretty much figured everything out for all that.
Okay. All right, so what I'm going to do, you both may be aware, there is a 6-month waiting period when there are minor children involved. It looks like your divorce was filed on March 25th. So what I would do then is just set this for a final hearing at the expiration of that 6-month period, which should be in late September, early October, whenever I can get a date following that 6-month period. And then we can finalize the divorce at that time. Ms. Heins, is that how you want to proceed?
Yep, that's fine.
Okay, Mr. Heins?
Yes, sir.
Okay, so the only other thing that I need the two of you to do to be ready for that final hearing, there's a couple final documents that I'm going to need you to have filed with the court prior to that hearing date. The first one is called a judgment of divorce, and that's the final document that finalizes the divorce between the two of you. That's a form that you can get online or wherever you got your forms to file for divorce. So I'll need you both to fill that out and submit that to the court, and then you'll need to get from the friend of the court a final order from them as well regarding child support. And as long as those documents are submitted prior to that final hearing date, then we can get everything taken care of at that time. Ms. Heins, do you have any questions about that?
No, sir.
Mr. Heins, do you?
Not at this time, no, sir.
Okay, so you should look for in the mail a notice. The court's going to send out a notice of the date and time of that final hearing. It'll be by Zoom, just like we're doing today. If you have any other questions, you can contact the clerk's office. That's all I have for today, and you're both free to disconnect at this time.
Okay, thank you.
Okay, Mr. House, are you able to hear me okay?
Yes, Sam.
Okay, we're on the record in House versus House. This is case number 2419615. The record should reflect that Mr. House is present today by Zoom video. This matter was set for hearing at 10 o'clock. It's now 10:05. Ms. House has not appeared. Mr. House, this is set for a status conference in this case today. And it looks like Ms. House was previously defaulted. And it also looks like you're set for a hearing in front of the court on June 24th. Is that your understanding as well?
Yes, it is.
Okay. All right. So the default means in terms of the division of any assets or debts, Ms. House has lost her ability to challenge that. So as long as it looks like your case was filed in March. So as you may be aware, there's a 6-month waiting period when there are minor children involved. So what I can do is set this for a final hearing at the court's next available date after that 6-month period expires, and then we can finalize the divorce at that time. Is that how you would like to proceed?
Yes, please.
Okay. So the only thing I'll need you to do prior to that final hearing date, there's a form called a judgment of divorce, and that's a document that finalizes the divorce once the court signs it. And then you'll also need to get from friend of the court a final child support order, and you can get that from the friend of the court office. As long as you submit those 2 forms prior to that final hearing date, then we can take care of everything at that time. The court will send you a notice of the date and time of that hearing. That'll be by video as we're doing today. Do you have any questions about how we're going to go forward?
No, I do not.
Okay. Okay, that's all I have for today then. Just look for that notice in the mail. And again, if you can submit those final documents prior to that date, and you're free to disconnect at this time.
All right, thank you.
Thank you. All right, our next hearing is set for 10:15, so we'll just take a short break until that time. All right, looks like we have everybody connected. If I can have the attorneys unmute, please, and we'll go on the record in Cotton versus Cotton, case number 2319201. And if I can have both counsel put your appearances on, starting with plaintiff.
Good morning, Your Honor. Jennifer Dusman-Coy on behalf of Kayla Cotton, who is present with me in my office.
Good morning, Your Honor. Katie Komorowski for the defendant, Mr. Ty Cotton, who is present on Zoom.
All right, thank you. We're on the record here today. We've got two motions by the plaintiff and two motions by the defendant. So we're set for hearing on all of these matters today. Looking at the nature of the motions, it makes sense to me to proceed with the defendant's motions first, since those could affect kind of what's in the judgment of divorce, which is part of one of the plaintiff's motions. So Ms. Komorowski and Ms. Dukes-McCoy, I did have a chance to review all of your written submissions, including the supporting documents that each of you filed with that. So I'm aware of the basis of each of the motions here. So Ms. Komorowski, if you want to start first with your motion regarding the tax exemption.
Your Honor, if I may on that, I talked to my client about that, and we are fine with the motion and the proposed alternating of years. So that's something that I don't know that we need to go forward with.
Okay, great, thank you. Ms. Komorowski, with that, anything else you want to address on that issue?
No, Your Honor.
Okay, and then Ms. Komorowski, your motion regarding kind of just generally the marital residence, you're asking for a number of different types of relief there. So if you want to proceed with that.
Sure, Your Honor. I would like to start with just clarifying the current status. I spoke with Mr. Cotton this morning, and the mortgage payments are current as of today. The extra $1,000 payment that he had made back in February has been returned to him, so he received $1,000 back. Currently, essentially, basically, and you've read everything you said. So, you know, the parties agreed at mediation, which was like 11 months ago, that they would refinance or sell the home within 6 months of finalizing the divorce. You know, at that time, we anticipated the divorce being finalized much sooner than that. It is the defendant's understanding that the plaintiff is not able to refinance the home. The plaintiff has had trouble making on-time payments. They have had a lot of back and forth with, you know, how is the payment being made? Is she transferring the payment to his bank account and then it coming out on auto pay? Is she paying it via check? Is she paying it on auto pay? And every month it seems to be different. And currently, it's my understanding that the auto pay was turned off, which, you know, makes the defendant nervous at this point. Again, there were payments that were not made on time in October and in February. And so also we've, you know, we're hesitant because, you know, if the divorce is finalized right now, then we're into December, which is not the best time of year to sell a house if it needs to be sold. And so we're just asking the court if the court would, you know, have either set aside the agreement to that we made and for the plaintiff to have 6 months to refinance and then resell, or for the plaintiff, if she's able to refinance rather immediately, or for the court to order the house to be sold.
All right, thank you, Ms. Dukes-McCoy.
Well, Your Honor, I don't know if the court recalls, but as we said in our motion, Mr. Cotton had asked the court to rewrite the parties' agreement before, and the parties agreed at mediation that my client would have exclusive use of the marital home and that she would have 6 months after the entry of the judgment, which is not yet entered, to refinance the home where it would be sold and the proceeds split between the parties. So that's something that the parties agreed upon at mediation. That's something that was entered in the court's October 19th order after we had a hearing on the issue. So I don't feel that it's appropriate for the defendant now to come before the court because he doesn't like how my client is making the payment. She's up to date on the payments. There was a snafu with the bank where she had to get that straightened out, but now that is all straightened out. Everybody is at zero on what, there's no balance that's owing and due. So this to me is frankly a non-issue, and I don't think it's ripe for the defendant to come before the court and say, we want the house to be sold. We want her to refinance immediately. We want the agreement to be set aside. I don't think any of that's appropriate at this point because it's not ripe at this point. So I don't think that that's something that the court can order until there's actually a problem here, and that's not been established.
All right, thank you. Ms. Komorowski, it's your motion. Anything you wanted to say in response?
Just that at the time that we filed the motion, there was a problem, and that it seems that the plaintiff has fixed it in between the time of filing and today's hearing.
Okay, well, I did have a chance again to read through the mediation agreement, prior orders that were entered by the court relating to this issue. I do think there's an argument to be made that Ms. Cotton, did technically breach the agreement because, it's pretty clear that she's the one responsible for paying the mortgage and for paying it on time. And there's at least one circumstance where that didn't happen, and it appears Mr. Cotton had to make payment and then she paid him back and made him whole. I don't think it's a good argument that, that was kind of raised in plaintiff's brief that, well, it doesn't say how she's supposed to make it and all of this. Well, putting her in charge, giving her the marital home and putting her in charge of making payments kind of assumes that she's going to pay the mortgage company and she's going to pay it on time. And that it's not going to be a situation where Mr. Cotton has to step in and pay it and then get reimbursed. I mean, yeah, it doesn't expressly say all of that, but I think that's the party's understanding. So I think there's a common sense view of how that should be interpreted. So I think there's an argument to be made. However, as Ms. Dutzman-Coy pointed out, I mean, for the court to find that there's been some type of breach or that there's some type of contempt here, in order to do anything about it, I think the court would have to find that there's some kind of damages to Mr. Cotton in some way. And I don't think that has occurred because, as Ms. Dutzman-Coy indicated, everybody is paid up and there haven't been any issues in terms of one side or the other owing money. So I think it's kind of a moot point for the court to go through that exercise because there wouldn't be any damages in a civil contempt scenario to award. And even if there was some type of breach of the mediation agreement, again, there aren't really any damages here to award. So and the court finds that there has been substantial compliance by Ms. Cotton, from what I can tell, based on what the parties filed. So again, I don't think the court has any basis at this point to invalidate the agreement because there haven't been any real material breaches of it. I don't think there's any basis for the court to find any type of contempt here. I don't have anything before me as to whether or not Ms. Cotton can refinance the home, but the parties agreed to give her 6 months from the judgment of divorce to do that, and she'll either be able to do that or she won't. In terms of the timing, both sides here have a financial incentive, if they are going to sell the home, to do that at a time when they can get the most out of it, because both sides are going to receive a portion of the equity. So I don't think there's any greater interest on the part of Mr. Cotton or Ms. Cotton in terms of when that happens. They both have an equal interest in maximizing, if it's going to be sold, maximizing the amount of equity that could come out of it. So I say all of that to say that at this point, the court finds that Mr. Cotton's motion should be denied, that the parties should continue to proceed towards finalizing a judgment with all the agreements in place that have been made. The court doesn't find that it has any basis to set those aside or award any kind of damages to Mr. Cotton for anything that's gone on during the pendency of the divorce. So the court will deny that motion. With regard to Ms. Dutzman-Coy, then moving on to your motion regarding the use of the cell phone. If you want to state exactly what you're asking the court to order with regard to that.
Yes, Your Honor. As we stated in the motion, the party's son is 13. He has his own cell phone. And the defendant was, during his parenting time, stating that the child needed to leave the cell phone at home. And my client had concerns about that because then she doesn't have a way to contact the minor child directly. He doesn't have a way to contact her directly. She's never interfered with the minor child contacting his father during her parenting time. My understanding is that at the most recent parenting time exchange, though, the defendant allowed the child to take the phone. So this may not be a continuing issue, but I would like to be able to have an order or an agreement in place that the child can use the phone during his father's parenting time.
Thank you. Ms. Komorowski?
I don't have any objection to that. I don't know if I received a copy of that motion, but I don't have any objection to the child using the phone during Mr. Cotton's parenting time.
All right, I'm not sure how the parties want to fashion an order on that. So I guess I'll leave that up to the attorneys to, as to the parameters of how you all want to agree. Ms. Dutzman-Coy, then your motion to enter, I know we have, both sides have submitted competing proposed judgments of divorce. And so Ms. Dutzman-Coy, what's your argument on that?
Well, Your Honor, we had submitted the proposed judgment. I think one of the defendant's objections was that the minor child's date of birth should not have been in the proposed judgment. That's something that I easily could remove from that. The parties also had a disagreement about who would claim the minor child on their tax returns. I think we've resolved that today, so we can include that in our judgment. The remainder, or the other objection, I think, was to the substance of the judgment was that there was nothing about the plaintiff's last name. My understanding is that my client does not want to change her last name at this point in time, so that was not included in the judgment. So I think those were, minor disagreements that we can, provide a new proposed judgment to the court. Again, it's the plaintiff's responsibility to provide that to the court. I did provide our proposed judgment to opposing counsel. I got a significantly different judgment back with, in my review of the defendant's proposed judgment, there were a lot of redundant paragraphs where we're saying things more than one time. There's a lot of unnecessary language. There's a lot of indication that the parties agree or that there's consent. There's signature lines. When we're doing this by, my understanding is anyway, when we're doing this by a motion for the entry of the judgment, it's just the court signing it, it's not the parties. So I don't think that language is appropriate. There's also a lot of information that would be more appropriate for a quadro for the division of the military benefits. I think the defendant was concerned that this would not, my judgment would not pass muster with DFAS or something like that. And that's why all that additional language was included. I researched that issue before I did the judgment, and my language is fine. I don't think that we need all of that additional language that just makes the judgment longer and frankly more confusing. And all of that language will be in a quadro anyway. We also did not agree upon a lot of the paragraphs within the defendant's judgment, and I can enumerate those, but there's quite a few different things that we didn't agree with, including some things that are not statutory either. So there's a fair amount of problems that I can see with the defendant's judgment. I feel that our proposed judgment contains everything it needs to and not more. And so we would ask that the court enter our proposed judgment.
Thank you. Ms. Komorowski?
As far as DFAS goes, I disagree. I don't think that the plaintiff's version would pass muster with DFAS. The expert witness that I was going to use last fall, Marshall Willick, I literally used his language that he recommends be used in divorce judgments for retirement and the SBP split. I also did not see language on the SBP and that this court ordered in the plaintiff's version, and I think that that needs to be included in the judgment. But besides that, I mean, we settled the issue on taxes, and I just wanted to just double check and verify what Ms. Cotton wanted to continue with her current name, or if she wanted to change it. I didn't see that in there, and so we've answered that question. I don't have any other issues with the plaintiff's proposed judgment besides just making sure that we have the correct wording for retirement in the SBP that this court ordered.
Okay, all right. So, you know, it's my view, number one, the court's responsibility in terms of entering judgments are to make sure that the judgment, number one, contains all the provisions that are required by statute. And number two, that it embodies any prior rulings of the court or the agreements of the parties. And quite frankly, both of them, I think, comply with all of those things. And so, you know, I don't view it as the court's responsibility to fly spec particular language that's in there. I think both proposed judgments would be appropriate for the court to enter. So what I'm going to do, I think both parties want to get this resolved. I think both parties want to get this entered sooner rather than later. So I'm going to put this back on the lawyers and the parties to work out whatever minor differences there are in those proposed judgments. And, you know, if you guys want to get this done, then somebody's going to need to give a little bit one way or the other, and probably both of you. But in my view, this is an issue that parties need to resolve and between themselves and counsel over the exact language of the proposed judgment. So the court's going to, again, order that parties reach an agreement as to the particular language of the judgment. So the way that I see this coming out today, and I'll let counsel, because this is partially motions on part of the plaintiff and partially motions on the part of the defendant. I'm going to let counsel get together and prepare an order. Number one, that reflects the agreements of the parties regarding the tax exemption. That reflects, for the reasons stated on the record, the motion regarding the marital residence for the defendant is denied. That reflects an agreement of the parties regarding the cell phone, and for the parties to submit a proposed judgment to the court within the next 30 days. For the court to sign. In terms of taking proofs, Ms. Deuce-McCoy, I'm just directing this at you as the plaintiff here. Have we taken proofs in this case?
We did, Judge, on November 2nd.
Okay, all right. So then the court will just look for the judgment of divorce sometime within the next 30 days. Once that's received by the court will sign that.
Thank you. Your Honor, I have one question about the proposed.
Sure.
Would the court like the front of the court's approval on that before we submit it to the court?
Yes, please.
Okay, thank you.
Okay. Ms. Komorowski, anything further from your side today?
Nothing further, Your Honor.
Okay, all right, thank you. That's all for this hearing. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, our next hearing set for 10:45. We'll take a short break. Okay, ma'am, on the iPhone, I just need you to connect your audio on your Zoom app. Okay, looks like we have council connected, so we'll go on the record in Rosowski versus Rosowski. This is case number 2419659. And if I can have the attorneys put your appearances on, starting with plaintiff, please.
I don't think she can hear you.
Ms. Doak,
I can hear,
Ms. Doak?
I can hear you now. I was having a little difficulty with my Zoom, but I can hear you now.
Okay, great. So can council go ahead and put your appearances on, please?
Thank you. Jody Doak, appearing on behalf of Scott Rosowski, the plaintiff.
And Wanda Lake on behalf of Kylie Rosowski, the defendant.
All right, thank you. And I don't know, is that, can you guys see there's an individual signed in on an iPhone? We can just see the top of her head. Is that Ms. Rosowski?
Yes, sir.
Okay, great. So she's present.
Yes.
This is set today for purposes of pretrial scheduling. I believe this case was just filed in April. So in terms of scheduling going forward, Ms. Doak, on behalf of plaintiff, can you tell me where things are at and
Sure.
kind of what do you think we need to do to get this resolved?
So Ms. Lasher and I have discussed this as well and both agree to this, I believe. We think that if we set it for mediation with Northern Community Mediation, that we should be able to get it resolved. And we could just probably come back and put proofs on. It's a divorce without children, and there's some separate property issues that need to be resolved. I think both parties recognize that they're there. So I think we could probably get it resolved without a lot of court intervention.
Thank you, Ms. Lasher.
Yes, we did have that conversation and we did agree to that.
Okay, how much time do you guys think you want to have to get that completed?
2 months, 3 months?
2 months, 60 days.
Okay. Okay, so we'll have community mediation to occur within 60 days. I'll just order that discovery to remain open for now, to the extent that either side wants to do any formal discovery. And then I will set it for a final hearing, status conference at about that 60-day mark. And if we're ready to proceed, we can finalize it at that date. If not, then we can talk further about how to go forward. Ms. Doak, any other dates I can address for your side today?
No, that's all, Your Honor. Thank you.
Ms. Lasher?
No, that's it. Thank you, Your Honor.
Okay, so I'll put that into an order. The court will send out the date and time of that final hearing, and all parties are free to disconnect. Thank you.
Thank you, Your Honor.
Okay, court calls Weber versus Weber. This is case number 2319475. That hearing was set for 10:45 today. It's now 10:50. Either side has appeared. Let's see, both in April and May, the court ordered the parties to submit a final judgment so that we could take proofs and finalize this case. The parties failed to do that in April, so the court set it for May. They failed to do that in May, so the court set it for today. The court also indicated that it would dismiss the case if parties were not ready to proceed today. Obviously, they haven't appeared, nor have they submitted a final judgment for signing. So the court is going to order that this file be dismissed without prejudice, and the court will not schedule any further hearings in this case. And that takes us to 11 o'clock. I don't see the parties yet on that file, so we'll take a short break. looks like we got everybody connected. If I could have council unmute yourselves, please. And we'll go on the record. This is in the matter of foreclosure of a parcel, I believe in Mishaway. And this is a claim for the proceeds pursuant to MCL 211.78, file number 2218928. If I could just have both council put your appearances on, please.
Good morning, Your Honor. Lucas Middleton appearing on behalf of the Otsego County Treasurer.
Good morning, Your Honor. Julius Moss. There's two different motions and two different clients I represent here. First on behalf of Mr. and Mrs. Bell, and then also on behalf of MZAR LLC.
Okay. All right. So Mr. Moss, anything that you wanted to state for the record? I mean, I reviewed the petition, Mr. Middleton. I got your response. I reviewed that as well. I mean, is there anything that the court, I mean, I think we've got a stipulation as to the requirements under the statute. So, I mean, is there anything for the court to decide today?
Your Honor, I would just add in response to Mr. Middleton's response, or reply to Mr. Middleton's response, that the one additional item that he brought up were that there were, I believe, liens from the homeowners association. However, as his response noted, they did not file notice of intention and did not file a motion as a claimant. And so we would just ask that as the only claimants in these matters for the respective properties that we be issued an order for the entire remaining proceeds.
Thank you. Mr. Middleton?
Yes, Your Honor. I agree with Mr. Moss's explanation with regard to where we stand. The only potential issues that we highlighted were the outstanding liens, but did point out the fact that Mishaway Association did not pursue a claim under MCL 211.78T, and due to timing issues would now be precluded from doing so. So really the only issue for the court today would be whether to award the proceeds to Mr. Moss's clients over any potential interest which may have existed at the time of foreclosure in the association by virtue of their liens. And so for that reason, Your Honor, I wouldn't characterize our response as a stipulation to the requested relief, but certainly we do agree that Mr. Moss and his clients followed the necessary statutory procedures.
All right, thank you. I did have a chance, as I indicated, to review the file in this case. I had a chance to review the claim filed by Mr. Moss's clients. I had a chance to review the response filed by Mr. Middleton, including all the attachments. The court finds that the claimants have complied with statute and are entitled to proceeds. This hearing was set for 11 o'clock. It's now 11:05 by my clock. No one else has appeared to contest the claim. And as both attorneys have indicated, no one else has filed no other parties with the potential interest in the proceeds have filed a timely claim or otherwise appeared. So the court finds that Mr. Moss' clients are entitled to the proceeds based on the amount of overage minus any statutory fees that need to be paid to the county or retained by the county. So Mr. Moss, if you want to prepare an order that reflects that, I don't know, did you submit one with your motion? I may have missed that.
We did not, Your Honor, but I'm happy to prepare one and send it over to Mr. Middleton, either for entry or under the 7-day rule.
Yeah, either with a stipulation as a form or 7-day rule. Okay, thank you. Mr. Middleton, anything further from your side today?
No, Your Honor, just that I'm confident that Mr. Moss and I can agree as to form and can send over 2 orders that comport with the court's ruling.
Okay, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.